Step into Judge Raquel West's courtroom, where every case carries weight and every decision has consequences. Today, several defendants are facing serious charges, and Judge West isn't pulling any punches. What unfolds here could alter their lives forever.
Good morning, you're Paul McCorvey.
Yes, ma'am.
And this is 24 DCCR 1914. Mr. McCorvey is charged with theft of property, and what is the announcement?
Judge, this was the one that it's taken a while clear to get some things from a probate court, which we did by the last setting.
Right.
It was reset because we was trying to confirm restitution amount with the complainant. She won't talk with us. I think the issue is Mr. Hoffmeyer is going to try to get with the investigator, see if they can confirm an amount. Because basically the restitution was going to resolve the...
Right.
Right, Judge, and the notes, according to Mr. Hoffmeyer, are that based on that probate order, just a very short conversation with the complainant. Now we have that in the transcript, should get us to a figure that should be able to resolve.
Okay.
And I can make sure that...
If you would, because that's where I thought we were last time. And so if you'll get with him and make sure Mr. Hoffmeyer gets on that quickly so that we don't have another reset based on that, please, ma'am. Thank you. All right, stay in touch with Mr. Lewis and he'll let you know when you need to be back. Good morning, you're Ashley Sanders. This is 24 DCCR 1650. We were waiting on audit. Where are we?
Judge, I'm happy to announce, thank you for the court being so lenient with us and resetting this a few times. Mr. Wimberly is actually here this morning with his client, my complainant. They did send me some documentation just right before docket. He's also indicated that his office is this week making notebooks for Mr. Kelly and myself and having everything scanned in. If we may just have one final, now that we have all that information, hopefully we can I can sit down with them, then Mr. Kelly and I can sit down and discuss it and see where we are, and we'll be ready to finally announce next time. But I did want to confirm we do have all that documentation, or
Okay.
it should be to me this week.
All right. Thank you, Mr. Wimberly. All right, so what I'm going to do,
And if you want to go ahead and put it on the trial docket, Judge,
no.
I certainly would understand.
Yeah, no, I just want to, let's see.
My only concern when I hear notebook is.
That's what I'm thinking as well.
What are we talking about?
Yes, sir.
It'll be about that thick.
Okay.
It would all be heavy.
So why don't we do this? When we come back next time, I want it all done and I want an answer. And so what I'm going to do is reset it to the 1st of January. That should be about a 60-day, a little more than that. I want everything hopefully turned over this week. That gives you an opportunity. So unless there's something else that comes up, I want it all gone through in an announcement at the next court date.
Yes,
Okay? All right, you're free to go. Thank you, sir.
Thank you.
Thank you, Mr. Kelly. Good morning. Are you Ryan Hodge?
Yes, ma'am.
And Mr. Hodge is charged in cause number 24, DCCR 1167. With the third-degree felony offense of evading arrest or detention with the use of a vehicle. The indictment alleges a prior burglary from 2015, and then also felony of bribing an officer in 2018 and possession of a firearm by a felon in 2018. We had reset that as well, some other stuff as well.
Those are out of state.
Yep. So what that means, though, is for punishment purposes, if Mr. Hodge, if you're found guilty by a jury, you would be considered a habitual offender, which means your minimum punishment, if you go to trial and are found guilty, is 25 years in prison, up to 99 years or life in prison. Do you understand? And we reset this case for you guys to watch the video, and have you had an opportunity to review the video in this case?
I've seen it prior, but
You've seen the video?
I think
Yeah,
he's
I've
seen
seen
it with his prior.
Okay,
previous
so you've
attorney.
seen the video, and have you talked to Mr. Kimler about it? Answer out loud.
do what, ma'am?
You've
Have
seen,
you
we've talked about the video.
We've talked about it, yes, ma'am.
Okay, and I want to make sure, so I have here on the tablet a plea bargain rejection. that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, to go on count one only, which is just the offense of evading arrest or detention, not those prior offenses, for a cap of 10 years, which means you would leave your punishment up to me. I can give you 10 years, I can give you less. It would depend on the information that was brought to me at a sentencing hearing. You have every right to reject that and have your case set for trial. I just want to make sure you understand what your possible consequences are and what your options are. And do you understand all of that? And so I'm also making the notation here on that plea bargain rejection that I've admonished you as to what the minimum will be if you're found guilty, which is 25 years in prison. You understand? And you want to reject that and have your case set for trial.
He's maintained his innocence.
All right. Then I do want to make sure you understand that after today, I will not accept a plea agreement. I'll get your case set on the trial docket. There won't be a plea. We'll let a jury decide, okay?
So, for any reason, we can look into it further, the facts and the evidence.
Well, that's what a jury's for. And so your attorney has discussed the case with the assistant district attorney. Their position is that it's an evading and they think they can prove that, and that's what we're going to go to trial, okay? That's what a jury's for. All right?
Fire on the other. No.
All right, ma'am, you're Brianna Clanan. And will your client waive the formal reading of the indictment?
She will.
Ms. Clanan, in cause number 25, DCCR 0446, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from March 8th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler? Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney, you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $250 fine.
I'll explain my scribbles, Your Honor.
Oh, that's CCCR. There would be
Yes,
a
there's
dismissal
miscommunication.
in cause number 25 CCCR 1119, and this will run concurrently with 25 CCCR
1053.
1053. Is that your understanding?
There should be another misdemeanor.
It was refused.
Oh, refused.
And what are those
The
cases?
dismissed one is resisting arrest, and they're all connected to this, Your Honor.
Mm-hmm.
The dismissal is a resisting arrest. The case to be pled is a DWI.
Okay.
All have the same criminal episode.
Let me look at something real quick. Oh goodness, I can't see that. If I test you this morning, will you be clean?
Be honest.
Have a seat in the jury box.
What?
Have a seat in the jury. Have a seat in the jury box. Let's get you tested.
The court is willing to accept it after the PSI.
Okay, and she'll waive the formal reading of the indictment in each.
Yes, Your Honor.
So, Ms. Randall, in clause number 25, DCCR 0246, you're charged with a state jail felony offense of theft of property with previous convictions. And that one's from November 21st of 2024. The indictment alleges you were previously convicted of theft April 4th of 1984 and April 11th of 1985, both misdemeanors, which would get us to this state jail felony level. It further alleges that you were convicted of a non-state jail felony offense of theft April 10th of 1989, and then again November 12th of 1991, and then after that was final, October 10th of 1994. And how do you plead to that charge? And are those prior offenses true? Or prior convictions true, excuse me. Are you entering your plea of guilty freely and voluntarily? And did you plead guilty because you actually did what they've charged you with? All right, give me just a second to get this pulled up so I can make that notation. I think that was 1 through 5.
5 or 6, depending on how we want to look at it.
If you love witnessing real courtroom drama as it happens, don't forget to subscribe and turn on notifications. We share real cases, real verdicts, and powerful moments of justice you won't find anywhere else.
Okay, and then so much quicker to go paperless, right?
Everything will be better when we go live.
Okay, in cause number 25 DCCR 0247, you're also charged with the state jail felony offense of theft of property with previous convictions from November 16th of 2024. This indictment also alleges you were previously convicted of theft April 4th of 1984 and April 11th of 1985 in misdemeanor cases, and that you were convicted April 10th of 1989, November 12th of 1991, and October 10th of 1994 in non-state jail felony thefts. And how do you plead to that charge? And are those prior convictions true? And again, did you enter your plea of guilty and true freely and voluntarily? And because you did what they've charged you with. In each of these cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Vasquez? Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a cap of 4 years in the institutional division of the Texas Department of Corrections, which means you're leaving your punishment up to me. And if I follow this agreement, it means that I cannot give you more than 4 years in prison. I can give you 4 years in prison, I can give you less. It'll all depend on the information that's brought to me and I see at a punishment hearing. You have every right to have a jury come in and determine 2 things. The first is if you're guilty or not, and then you could leave your punishment up to that jury. If we go forward this way, you're waiving that right, and is that what you want to do? All right, state tenders number 1 in each case.
No objection.
It's admitted. And do you also understand, ma'am, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Is there any evidence that Ms. Randall's not competent?
No, Your Honor.
All right, Ms. Randall, I'm going to find in each of your cases that you entered your pleas of guilty and true freely and voluntarily, find that you're mentally competent, find sufficient evidence to find you guilty in each of your cases. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information on you, your cases, and then we'll come back later for sentencing. Anything that you think is important for me to know, make sure you get that information to Mr. Vasquez, and he will present it to me on your behalf when we come back. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there. All right, we'll see you back at sentencing.
Thank you, Judge.
Yes, sir. Mr. Gertz, you have Shay Morgan. Good morning.
How are you?
Good. How are you?
Hectic.
It's a Monday.
It was supposed to be a slow Monday, and it's turned into the opposite thing.
That's usually how it goes. Good morning. You're Shay Morgan? Yes, ma'am. And Ms. Morgan, in cause number 24, DCCR 2102, is charged with theft of property. And what is the announcement?
Judge, we're going to ask for a regular resetting. Ms. Malfino and I are discussing a potential resolution. I've also been given some documents from my client that I think will help inform that process. And so,
Any issues?
No, Judge, it looks like we do, at least for purposes of this announcement, have a restitution figure, so we wouldn't need time to develop that.
Okay.
We can just share that information with the council.
Okay. And the case looks old, but I realize that you were just hired in the end of July, so we'll just do a normal reset. And then, Ms. Morgan, make sure you stay in touch with Mr. Gert so you guys can go over everything. We'll try to get an announcement at the next court date. All right, you're free to go. Thank you.
Have a good week.
Thank you. You too.
I guess I'll see you tomorrow.
You have something, maybe?
If they make me a fire sale offer, maybe I can.
We'll see.
Get away off the devil's cabbage.
All right, you're Brianna Clayton? Not very smart to be doing anything while you're waiting on court, is it? How old are you? You're 20. So it is time to make better decisions, because smoking marijuana or anything else that has THC in it is going to be a violation of any probation, and it can put you in prison. It's that serious for you to get your life on a different direction. Make sense? All right. Now I can't remember how far I got at all. Let's start over. And she'll waive the formal reading of the indictment.
So wait,
Did I go through it all or no?
you got real close. We had just mentioned the misdemeanor cases. One was being dismissed, one was being run concurrent.
Okay. So we've already gone through, and she entered a plea of guilty. We went through, it was a 3-year deferred, $250 fine. All right, so we're gonna start back where we left off, Ms. Clayton, and let me go back and ask, did you enter your plea of guilty freely and voluntarily? And did you plead guilty because you actually did what they've charged you with? And then you understand what your punishment is that you're agreeing to, which is a 3-year deferred with a $250 fine, correct? With the dismissal in one of the misdemeanors, and then my understanding is you're gonna go plea on the other misdemeanor for a probation as well, correct? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Clayton is not competent?
None I'm aware of, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. If you test positive for anything between now and when you come back, you run the risk of me not accepting your plea agreement. Do you understand? I want her tested when she goes in for her PSI.
That's alcohol.
And I ran, yeah, that's alcohol also. You don't need to be using anything. No alcohol. You're not even legal to drink alcohol. So by your reaction to Mr. Kimler, it shows me that you're doing that as well. You understand you can go to prison for 10 years because of this? What y'all did, I mean, y'all jumped out of the car and hid and ran and all kinds of stuff. And it's not funny.
I'm not trying. I laugh when I get nervous.
Okay. I mean, you're lucky that this didn't turn out worse with you guys running and hiding from the police. It could have been very bad. So if you want your life to go in a whole different direction, you're going to have to make some much better choices. Okay? All right. So you need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there, and we'll see you back at sentencing.
Thank you, Your Honor.
In today's session with Judge Raquel West, we saw a range of serious cases and important decisions. First, Brianna Clayton, charged with evading arrest with a vehicle, she pleaded guilty and received a 3-year deferred probation along with a $250 fine. Judge West emphasized how serious probation violations could be, and this case illustrates the importance of making better choices to avoid more severe consequences. Then, Hall McCorvey is charged with theft of property. The court is still working to determine the proper restitution amount, and his case is closely monitored to ensure accountability. Next, Ashley Sanders is also facing theft charges. The case is awaiting final documentation and resolution, showing how critical proper paperwork and cooperation are in the judicial process. Then we have Shay Morgan's case involves theft of property as well, and it has been reset to allow for discussion of restitution, demonstrating the court's effort to balance fairness with legal procedure. Miss Randall, who has multiple prior theft convictions, pleaded guilty with a 4-year cap, pending a pre-sentence report. This highlights how past offenses impact current sentencing, and how the court carefully considers the individual's history before final decisions. Finally, Ryan Hodges faces a much more severe situation. Charged with evading arrest with a vehicle and having prior convictions including burglary, bribery, and possession of a firearm as a felon, he is considered a habitual offender, and the consequences he faces are significantly harsher. Across all these cases, Judge Raquel West's courtroom showed the weight of accountability, the importance of honesty, and how every decision, from plea agreements to probation, can change a person's path. These sessions are a reminder that actions have consequences, and the court carefully examines each detail before determining the outcome. If you want to see more real courtroom drama like this, learn about the cases, and understand the impact of legal decisions, don't forget to subscribe to the channel, hit the bell, and follow along as we break down real-life justice unfolding in front of your eyes.